First up, we have Mr. Nadeem Ashraf, who's Member Punjab of the National Commission of Human Rights. Nadeem Saab is a law graduate and holds a postgraduate diploma in public administration from UConn, USA, and advanced certification in public sector management from Harvard University, USA. He has been a member of Pakistan Administrative Service and has served in various field and secretariat assignments for over 3 decades. During his career, he worked as divisional magistrate and district magistrate in various districts of Punjab, Additional Secretary Home Department, Secretary Education, and Senior Member Board of Revenue, Punjab Government. He has also served as Federal Secretary of Ministry of Overseas Pakistanis and Secretary Ministry of Human Rights. He has the experience of heading public sector organizations including Overseas Pakistanis Foundation and Telecom Foundations. Mr. Nadeem Ashraf has an extensive exposure to human rights issues both at the ground level as well as the policy level, and interacted with international human rights organizations and has represented Pakistan at such forums both within and outside Pakistan. Thank you for joining us today, sir. Our second panelist is Ms. Fauzia Waqar. No, I do. Yeah, but I think this thing froze. Can I read it here? Yeah, so Ms. Fauzia is an internationally recognized expert and visionary leader on gender issues in development. She has vast experience of working with government and civil society organizations, both in Canada and Pakistan, where she led large programs on human rights and women's empowerment. She was also the chairperson of Punjab Commission on the Status of Women, where she succeeded in placing gender equality at the core of the government processes by providing concrete evidence derived from unique data collection mechanisms that she pioneered. She currently serves as an advisor to various development projects, providing technical assistance to the governments in Pakistan, and also heads a development consultancy, RA Center for Management and Development. Fauzia serves on various policy-making boards and committees. She joined the board in 2019. An important part which isn't here is that Ma'am Fauzia was the head of the Punjab Commission on Status of Women, which implemented a massive program on women's marriage rights in Punjab as well, and we'll get an opportunity to hear from her on this. We are also honored. Yeah, that's me. Yeah, so I'll use this, yeah. Dareen Al-Hajj, who currently works as the Senior Program Manager at American Bar Association Rule of Law Initiative. In the past, she has been a freelance consultant for the United Nations Development Program, World Food Program, Oxfam, Peace Track Initiative, and other organizations. She has also worked as the Regional Program Manager with the United States Institute of Peace. Dareen also worked for the Center for Victims of Torture as an advocacy and capacity building officer. She was the executive director of Aleph Act for Human Rights, an NGO based in Lebanon, and still serves as a board member of that organization. Dareen trains, mentors, and advises on organizational development, international human rights, refugees, IDPs protection, humanitarian law, peace building, and NGO capacity building related themes. Our presenters today are Fatma Bukhari and Rehan Safdar. Fatma is currently serving as the CEO of Masawi, and Fatma is great, and so is Rehan. And I've introduced myself. So without further ado, over to Fatma and Rehan for presenting the findings of the diagnostic study. For the panelists, it will be projected on that screen as well.
Thank you very much to the moderator, my colleague, and also our esteemed panelists joining this session. And to all of you who are joining us after lunch, which is always a little bit of a difficult task. But we promise to share with you something that we think is very important to assess what is the actual state of the implementation of existing marriage rights protected by the existing legislation that is in place, particularly in Punjab for our context, but also largely Pakistan. Some of these insights are transferable, useful for cross-analysis as well. So if I can have the next slide, please. So first I would like to share sort of a snapshot. So we did a pilot study, a diagnostic study, in one district of Punjab, in 7 union councils of that district. And the key data sources for that study included a knowledge, attitudes, and practices survey with Nikah registrars and interviews with union council officials. We did the survey with Nikah registrars. Approximately 50 Nikah registrars participated in that survey. And 5 UC secretaries were interviewed in depth. And then in addition to that, we also we did a diagnostic analysis of registered Nikah namas within those 7 union councils, and the total sample size of the Nikah namas that we reviewed to extract key trends was 650, and after data cleansing, we relied on 627 of them that form the basis of the findings that we will be sharing with you. So the key findings, I will share briefly the key findings of this cumulative exercise, both our analysis of the registered Nikah namas and also the interviews and surveys that we conducted with the relevant stakeholders that are primarily as one of the key actors responsible for implementation and therefore access to these rights. And so these are broadly the 3 key findings that we want to put forward today. One, that there are concerning gaps in the implementation of existing laws, and as Umar mentioned, we will have to look at what are the causes for non-implementation. But the key things that we found that reflect that gap in implementation is that pursuant to there being a law in Punjab that prohibits and also makes it criminally, an offense to cut out columns or leave columns blank in the Nikah nama, a majority or a large number of registered Nikah namas contained these crosses and blanks with regards to the key rights that are contained in those Nikah namas. Similarly, key information was missing in several of the Nikah namas reviewed, where essential details such as the bride's national identity card number was missing. And, approximately that was the case in 48% of the Nikah namas that we reviewed. So almost half of the Nikah namas did not contain information about the bride's NIC. And that, as we later will discuss, is essential if we want to know whether the bride is of legal age to marry or if she's an underage bride, which would then attract a conversation and criminal liability on child marriages. So that data is missing, so that analysis cannot take place. And again, not correctly filling out the Nikah nama with information is also a non-implementation of the existing law. The second key finding that we want to share here is that perceptions and biases of Nikah registrars impact the accurate filling out of the Nikah nama. So they impact the correct filling with regards to, making sure that all columns are filled out, but they also impact the rights-based columns in particular. So these are some of the statistics that we can share. So what we reviewed is that 49% of the Nikah registrars believed that they can cross out the delegated right to column through mutual agreement of the elders of the family. And the diagnostic analysis confirmed that this column was in fact crossed out and left blank in 40% of the Nikah namas. So the perception that they can do that then reflects in the practice of them actually crossing out or leaving those columns blank in the Nikah nama. Similarly, 50% of the Nikah registrars believe that women should not freely seek the delegated right to divorce in the Nikah nama. And 76% perceive that the wife's right to maintenance, monthly maintenance, in the marriage is subject to her obedience to her husband. and 90% thereafter believed that women do not have the right to work independent of the husband's permissions. So these are some of the, the entry points that we, can see some of the perceptions and ideas that nikah registrars hold. And thereafter, you can draw linkages on the specific rights that they might actually have an impact on. The third and final, key finding that we want to share is that there are gaps in awareness, understanding, and capacity of nikah registrars and also UC officials, which also serve the oversight function of nikah registrars, on marriage rights and their related laws. So 86% of the nikah registrars believe that a husband is not legally bound to pay haq meher if the wife gives up this right of her own free will. Despite there being no legal backing for this, practice or this belief. Similarly, substantive rights that are afforded in the Nikah-Nama that we have discussed at length in this symposium on several occasions were less visible in the Nikah-Namas, and some of these rights that were particularly absent were the delegated right to divorce, monthly maintenance, and these kind of provisions. So these are the key findings that are, cutting across both data sources, but we have also, disaggregated them further to show individual trends, which I will be passing on to now my colleague Rehan to take us further. So first we will start with the findings of the CAP survey, the Knowledge, Attitudes and Perception survey that we conducted with the nikah registrars.
Thank you, Fatma. So with this, I'll move forward with the CAP survey findings. So just to give an overview of what's been covered in the CAP survey, these were the thematic areas that we covered in the Nikah-Nama and marriage rights, women's marriage rights. So the CAP survey was based on these thematic areas that include the protection of women's rights in the Nikah-Nama and marriage laws, validity of the marriage and Nikah-Nama, and then there were the different forms of dissolution of marriage and the procedures involved in the marriage laws, and then there was the legal provisions regulating the Nikah-Nama and marriage. There were the other areas were the child and forced marriages, as well as the socio-cultural and religious beliefs affecting the woman's access to those marriage rights that are granted in the Nikah-Nama. So when the nikah registrars were asked about the mandatory requirements to establish a valid Nikah-Nama, it was observed that the consent of the bride was given lesser priority, and the other things like haq meher and witnesses were given more priority to these substantive rights. So for instance, when it was asked about the valid consent of the bride, 40% of the nikah registrars perceived that a woman can give her consent without any duress or influence. That means that 60% of the nikah registrars were not familiar with the concept of the valid consent in the marriage. Similarly, 40% perceived that a woman can give consent to a person she is marrying with. So again, that applies if we reverse the stats that says that 60% aren't familiar with what a valid consent is. Similarly, when they were asked about the free consent to terms of the marriage, which is basically a civil contract, they think that 46% of the nikah registrars perceive that the bride basically can give free consent to the terms of the Nikah-Nama. And again, when they were asked about other mandatory requirements, that is the age of the bride and the groom or the appropriate filling of the Nikah-Nama, 54% perceived that the marriageable age of the bride and groom isn't the mandatory requirement as per law. So it means a marriage can be solemnized irrespective of the age of the bride and the groom, and that also makes a point for the child marriages in our country. And similarly, 62% perceived that appropriate filling of the Nikah-Nama isn't the mandatory requirement as per the law. So moving on to our next slide. So now we'll be sort of discussing the Nikah-Nama's rights as per different clauses that protects women's marriage rights in Pakistan. So when it was asked about the haq meher, almost 90% of the Nikah-Namas perceived that the nikah nama or the marriage gives the right to haq meher to the woman. But when they were further asked about the exclusivity of this right for the woman, 44% think that it doesn't. Basically haq meher exclusively belongs to a woman or to a bride. So that means 54% still think that haq meher isn't an exclusive right of a bride. Similarly, when they were asked about whether a bride can freely use the haq meher, 48% think that they can use, the wife or the bride can use the amount of the haq meher as she freely chooses. And similarly, when they were asked about the payment of the haq meher, only 26% perceive that haq meher is payable to wife upon demand, upon divorce or a husband's death. That signifies that the nikah registrars aren't familiar with the exclusiveness of this right to haq meher, that they think that the nikah nama protects this right. Similarly, when certain questions related to socio-cultural factors were asked about the right to haq meher, 72% of the nikah registrars perceive that haq meher serves as a protection against a threat to divorce. But when they were asked whether the high amount of haq meher would put strain to a husband and wife's relationship, 82% perceived that a high amount of haq meher could lead to a strained relationship between a husband and a wife. So when they were asked about the bride's right to discuss and negotiate the terms of the nikah nama, an overwhelming majority, almost 98% of the nikah registrars agreed that the women should negotiate the terms of their nikah nama. But here comes another issue that is linked to the socio-cultural factors and religious beliefs, that 52% perceive that it is not culturally appropriate for the wife or the bride to discuss the terms of the nikah nama. And men and elders, 92% perceived that men and elders or the elders of the family are in a better position to negotiate the terms of the nikah nama instead of the women or the brides. And when they were particularly asked about the religious stance on this, the negotiation of the terms of the nikah nama, only 24% disagreed that our religion doesn't give this right. That means 76% agreed that the bride can negotiate the terms of the nikah nama as per our religion. But the thing is that socio-cultural factors are more influencing these, are sort of curtailing the woman's rights in marriage. So when they were asked about the wakil's role in negotiating the terms of the nikah nama, 47% think that wakils are in a better position to negotiate the terms of the nikah nama instead of the bride. And so moving on to our two different concepts that are involved in the marriage, khula and the delegated right to divorce. So it's been observed that there is general confusion among the nikah registrars, who are the key stakeholders in sort of who are involved in the process of the marriage or in the registration of the nama. So they are about the concepts of khula versus the delegated right to divorce. When they were asked that whether the women have the right to divorce in the nikah nama, so only 56% reported that women have the delegated right to divorce in the nikah nama. And similarly, when they were asked that whether a woman can so the woman should freely seek the right to delegated divorce or not, only 50% agreed with this, that the woman should freely seek the delegated right to divorce. But when they were asked whether khula is an independent right of the woman or not, only the 56% perceive that khula is not an independent right of women to seek divorce. So these are some of the critical findings that also signifies that the nikah registrars should be involved in this process, and they should be informed about the khula and the delegated right to divorce, what these rights are and what's the purpose of these rights. Similarly, 80% of the nikah registrars perceive that the khula and the delegated right to divorce both are the same concept, not the different concept. And the procedure for exercising the delegated right to divorce is different according to 78% of the nikah registrars, which is in contrary to what actually is applicable in the Muslim family law ordinance. And similarly, when some questions related to socio-cultural factors were asked, 52% perceived that giving the delegated right to divorce in the Nikah-nama is against social norms. And they also perceived that giving the right to divorce in the Nikah-nama would increase the divorce rate in the society. So when they were asked about their legal responsibilities that the Muslim family law gives them or allows them to fulfill, so their personal biases were more reflected in fulfilling those responsibilities, legal responsibilities. So 49% still perceived that the nikah registrar can cross out the delegated right to divorce column through mutual agreement of the elders. Rather, our law says that they cannot even cross out any column of the nikah-nama. Rather, they should fill all the columns of the nikah-nama with the specific responses of the bride and the groom. Similarly, 22% still perceive that there is no punishment for misreporting of the dower amount in the nikah-nama. And the same was seen in our conversations with the Union Council officials and as well as the nikah registrars, that this issue isn't taken seriously, and they have seen instances where people come to the local government offices and complain about the nikah registrars that they haven't properly filled the dower amount in the nikah-nama. Similarly, when they were asked about the filling of the nikah-nama with the specific responses, 26% still think that they don't have 26% only think that they have the legal responsibility. That means 74% aren't aware of their legal responsibility in terms of filling of the nikah-nama. Similarly, they think that it isn't their legal responsibility. 24% only think that it's their legal responsibility to ensure official consent of the bride, official consent of the wife in case of a polygamous marriage. And similarly, 22% still think that they have the discretionary power to cross out the columns if they disagree with any of the conditions that the bride or the groom, the bride and the groom or the parties to the contract have agreed upon. So moving on to our next part, which is the attitudes towards key rights of the woman. Again, their personal biases and perceptions we have seen that their personal biases and perceptions have implications for women's marriage rights as well as their fundamental rights as well. So if they were when they were asked about the right to work independent of the husband's permission, only 10% think that the women have the right to work independent of the husband's permission. That means still 90% aren't aware that it's a fundamental right. They can exercise this right. They don't have any restriction. They aren't bound to sort of have any. And 74% stated that a wife isn't allowed to work professionally without her husband's permission. And when it comes to the question on the wife's support to husband's family, 58% think that a working wife should support the family of their husband as well. And when it comes to the right of maintenance that is linked to the obedience of the wife, 76% think that 76% of the nikah registrars perceive that the wife's right to maintenance is basically linked to the obedience of her husband. Similarly, 74% think that a wife cannot visit her relatives after the marriage without the permission of the nikah registrars.
So Rehan just shared the key findings, and rather the detailed findings from the conversations with Union Council officials and the surveys with the nikah registrars. And now I will just share the findings from the 627 registered nikah namas that we reviewed from this one particular district in Punjab, and what were the key trends just by looking at the nikah nama that we were able to identify. So we basically did an analysis, not of all the columns of the Nikah-Nama, but a few that we think are important and have implications for marriage rights. One of them, we looked for column 4, which contains the bride's computerized national identity card. We looked at column 6 for bride's age. We looked at column 13 for haq meher, 17 for any special conditions in the marriage contract, column 18 on the delegated right to divorce, column 19 whether there are any conditions on the husband's right to divorce stipulated in the Nikah-Nama, column 20 with regards to the monthly maintenance of the wife during her marriage, that is the obligation of the husband, and 24 the date of the registration of the Nikah-Nama, which is a different date from the date on which the Nikah-Nama takes place. And we did this to assess to what extent there was compliance with the existing legal framework and the responsibilities that they put. So if we look at the first of these, column 4 and 6, we found that 48% of the Nikah-Namas did not have the bride's CNIC information present. And out of these 48%, 75% had still ages written between 16 to 18 years. So those ages were still written by hand in the Nikah-Namas, but it wasn't clear on what basis that information was there because the Nikah-Nama did not contain the CNIC number. And so if you see, comparison with regards to the missing number, the brides that had a missing Nikah-Nama ID card versus the grooms that had a missing ID card, that's a stark difference. So it's also more commonly known that men tend to have more ID-related documentation available versus women, so that's also there. But at the same time, what is important about the information on age, the verification of age, is that if that is not there, it is unclear and there's no way to find out if this is a child marriage or not. And especially in the bracket of 16 to 18, there may be, concerns that this could be a child marriage. And on the data, that is the specific Nikah-Namas that mentioned underage, brides and grooms, there were a total of 10 marriages which involved underage brides and grooms, 5 each, and they were mentioned, the particular underage in the thing. The brides in this case were 15 years old and the grooms were 16 and 17. Which is, not aligning with the legal age of marriage for men and women in Punjab. On dower and haq meher, only 8% of the nikah and monthly maintenance, only 8% of the Nikah-Namas contained the right to monthly maintenance and allowance, which is the non-nafka. While 39% of the Nikah-Namas had this column crossed out or left blank. And I want to reiterate here again that it's a problem for them to be crossed out and left blank. That's a separate problem of implementation of the law, in addition to the fact that a substantive right is also missing. And if you compare the presence of the haq meher in the Nikah-Nama, that's 98%, but if you compare that to the monthly maintenance, that's only 8%. So there's a stark difference between the priority that's given to the haq meher versus the monthly maintenance within the Nikah-Nama. And there's a further disaggregation here as well. Similarly, on column 17, which allow the bride and groom to add conditions to the Nikah-Nama, 51%, that is more than half of the Nikah-Namas, did not contain any special condition, while almost 30% of the Nikah-Namas had this column as well, crossed out or left blank. So we do see a consistent larger trend of crossing out of certain columns or leaving them blank. And I think when we further disaggregated what were some of the commonly placed conditions within these special, where they were available, they were, as mentioned here, whether return of dowry, some financial compensation against the husband's right to divorce, some maintenance amount, some compensation against polygamous marriage. Going ahead on the delegated right to divorce, and I think that one is perhaps one of the largest numbers that we have in terms of percentage. 97%, that is almost 100% of the Nikah-Namas did not have the delegated right to divorce, out of which 40% of the Nikah-Namas had this column crossed out or left blank. So not no, crossed out. So there's not even a conversation about it. And, that is an important finding of this as well. And we have further disaggregation on the conditions placed as well on column 19 for the groom's right to divorce. Next, please. So the date of registration of the nikah, which is again an obligation on the nikah registrar pursuant to the law that is in place in Punjab. So we saw that the date of registration, the date of the nikah was there in almost all cases, but the registration date was missing. Was not there in 74% of the nikah namas. So, we don't have that information, and that also corresponds to showing a gap in nikah registrars fulfilling their essential duty, which is to register the nikah nama, and of course it attracts a penalty as well. So these are some of the key, statistics and findings that we wanted to highlight for this particular discussion. To start a conversation on, what is the state of implementation, to what extent, different factors contribute to that, and some of the next steps that we have, building upon this data, is to, sort of use these findings as an opportunity to identify focus areas for our engagement with nikah registrars and UC officials who have the primary responsibility for the actual rollout of these rights. We do intend for that engagement to take a formal a shape. So we're thinking about what kind of materials, curriculum, dissemination strategy needs to be in place for that engagement to be successful, and we think input from our esteemed panelists here would be essential as well. And similarly, we do want to eventually support better implementation at the local government level of the laws that have been, drafted within and, passed in this province for these purposes. So, and to support, implementation of the provincial laws as they protect existing, rights of women within the nikah nama. So I'll leave it there and pass it back for taking the conversation forward.
Thank you, Fatma. Thank you, Rehan, for the presentation. I think my opening question to all panelists, and Nadeem Saab, we'll start with you, and then Fawzia and Dareen, is how do you read it? What are your preliminary thoughts on the data that you've seen? I'm sure it's not news for either you or Fawzia, but...
Okay, thank you very much. It is a pleasure to be here among the esteemed panelists and young persons who would be taking this forward of implementation of laws. First of all, I would like to introduce the organization which I am representing. It's the National Commission for Human Rights. It's an autonomous commission of the government of Pakistan. It is independent of the government, but it's a state commission. And it has been set up under the Act of 2012. Why this? Every member state of the United Nations is required to have one independent human rights institution which would be funded by the government but would be independent of government control to monitor the human rights situations in that country. And for that purpose, we have been given judicial powers to take cognizance of violation of human rights. There are a number of complaints which come to us. The composition is that we have one member from each province. So I'm member from Punjab, then we have the chairperson and one member from minorities. This commission came into existence in November last year. Section 9 of the Act, as Fatma Sahib, she mentioned that the way forward, where do NCHR come in? The powers which have been conferred to the Commission have been spelled out in Section 9 of the Act. And those powers, one of those powers I've mentioned is investigation of complaints for which we have judicial powers. And then another is very important, where here that seems very relevant, is that we can recommend to the provincial government to legislate on issues pertaining to human rights where legislation is missing, is non-existent, or where there is legislation. Like here we have the 2015 Act coming in to fill in column, but it's not being, there is a gap in implementation. So we ask the provincial government or the federal government to take policy measures. I will give you a few examples that the child rights, there were no coordination at the district level. The number of cases of child abuse is rising in Punjab. So we recommended to the provincial government to have more coordinated efforts. there was issues of the minorities and against sanitary workers, there was a column of religion being mentioned. So that was very demeaning. So we told to the provincial government to delete that, and they've done that. They've issued a notification. So these are the powers which the commission have. We recommend them, and if they defy, then we can fix in hearing, and we can go back to them and invoke a coercive powers which have been given in Section 18 of our Act. Now when CEO Musavi and Umar Sahab, they came to NCHR office, and they said that this is an area which we are working on women marriage rights. I was very intrigued regarding, because it's a limited subject, it's not a very vast, but at the same time it is a very challenging. Why it's so challenging? Because you are here not only seeking the implementation of laws, but you are also struggling against the cultural and social values, which are very deeply entrenched whenever a marriage takes place. And mind you, there was no written marriages before 1949. Those who are law students, they would be knowing that the first written marriage became, contract became, Nikah-nama became compulsory was under the 1949 Marriage Registration Act. Then there have been various amendments, and now we have the 2015 amendment also. Why is the written contract essential? This is contract, those who are law students here could say that contract can be oral also.